Okay, good afternoon. Thank you for joining us today for a training on domestic violence survivors' rights regarding rent and utilities. So, the purpose of today's training is for you to learn how California law can help you kick your abuser out of your rental unit while still being able to afford living there. Also, to learn about other tenant protections under California law for survivors of domestic violence. Why this matters. So this matters for a couple of reasons. If you share a rental unit with your abuser and you're both on the lease, you might be concerned that if you kick that person out, then you'll be responsible for all of the rent. Fortunately, that's not the case under California law. And there are also some other protections that should make you feel more comfortable about getting the help that you need. So first of all, a restraining order. Obviously, under California law, if you've suffered abuse from your partner, then you can seek a restraining order against them. As part of the restraining order, you can ask the court for a kick-out order, which is an order basically saying, that person's not only restrained from contacting you or getting close to you, but they're also kicked out of the shared residence. If you are in a situation where you want to seek a restraining order, generally you can either hire an attorney or, if you go to the courthouse, they have free attorneys there that can help you fill out the paperwork and get everything filed that you need. For that, I recommend getting there early in the morning. A lot of times there's a wait or a long line, and you want to make sure that you get in that day. So get there early, but there are attorneys there that can help you do that. So if somebody has been kicked out pursuant to restraining order, California Civil Code Section 1941.6 says that a person who is excluded from the rental unit by a court order remains liable for the rent along with all the other tenants. But the landlord is no longer liable to the excluded person for any of the provisions of the lease. So what does that part mean? That means if somebody gets kicked out of their rental unit because of a court order, either restraining order or criminal protective order, they're not excused from paying rent if they were on the lease. So they still have to pay, just like the other tenants or tenant. And the landlord is no longer liable to them for any of the provisions of the lease. What does that mean? That means the landlord, generally a lease is basically an agreement. The person is going to pay rent. The landlord is going to provide a place to live. But in this situation, the person's still obligated to pay rent, but the landlord is no longer obligated to provide a place for that person to live. So while they keep paying, they don't get any of the other benefits of the lease, whether that's the rental unit, the parking, use of, amenities, whether it's a pool or a gym, laundry facilities, things like that. The landlord is excused from providing any of those things from the lease to that person who's been kicked out, even though that person is still required to pay rent. And then the landlord is also required to change the locks upon request. So in this type of situation, if you've gotten a restraining order against somebody and have them excluded, if you notify your landlord and you provide them a copy of the restraining order, they're required by law to change the locks at your request. And if they don't change the locks within 24 hours, you can change them yourself. Couple caveats to that is that you have to use a lock of similar quality, and then provide a copy of the key to your landlord at the first opportunity. So the abuser still owes rent. Also, even though we just saw how the civil code says they're still liable, as part of a restraining order, if you want to make things more clear, you can ask the court for an order requiring that person to pay rent. Family Code Section 6324 allows the court to make an order determining the payment of any liens or encumbrances during the time the order is in effect. So that would include paying the rent, making a car payment, paying the utilities, insurance, anything that they were paying before, you know, the abuse occurred, the restraining order is issued. The court can order them to continue paying that for the whole length of the time that the restraining order is in effect. So let's talk about your right to call the police. This is actually a new protection that's been added to California law recently. So your lease cannot limit your right to call the police in case of emergency. So basically, if there's something in there saying, you can't call the police or if you feel you're threatened or anything like that, that's not valid. It's unenforceable. You always have the right to call the police in case of emergency. Also, if you do, your landlord cannot penalize you or threaten to penalize you for calling the police or emergency services to your rental unit. And this is also a defense to eviction. So if if you do call the police, and later on the landlord tries to evict you for some reason or somehow based on that, you can assert Civil Code Section 1946.8 as a defense. Uh, and as long as there aren't other reasons for eviction, then you'll be able to defeat that case. So you can also terminate your lease if you've been the victim of abuse. So Civil Code Section 1946.7 allows you to terminate your lease if you have been the victim of domestic violence, sexual assault, stalking, human trafficking, elder abuse, a crime that caused serious injury or death, a crime involving a firearm, or a crime that involved the use of force or the threat of the use of force. So let's talk about how you would go about that if you want to terminate your lease in one of those situations. To terminate your lease under Civil Code Section 1946.7, first of all, you have to give notice to your landlord in writing. And you need to provide either a copy of the restraining order, emergency protective order, or criminal protective order, that's either protecting the tenant or a household member or an immediate family member of the tenant. Um, or you can provide a police report stating that the tenant, household member, or immediate family member filed a police report alleging they were the victim of one of the aforementioned crimes, or any other form of documentation that reasonably verifies the occurrence of one of the aforementioned crimes. Or, and this is a really helpful one too, you could provide documentation from a qualified third party based on information received by the third party while acting in their professional capacity that the tenant, household member, or immediate family member is seeking assistance for physical or mental injury resulting from one of the crimes we just spoke about. So what's a qualified third party? Qualified third party could be, a counselor, whether that's a domestic violence or sexual assault counselor, a therapist, human trafficking caseworker, victim of violent crime advocate. Basically, if you're in a situation where you're, participating in services or seeking some type of counseling, or if you're working with the DA's office with a crime victims advocate, any of those people would suffice. If you get a written statement from them indicating that you were, the victim of one of the crimes we mentioned above, the landlord has to let you out of the lease as long as you give them notice in writing as well, or her. So the notice to terminate your lease, this is one limitation on it under Civil Code Section 1946, must be given within 180 days of the court order, police report, or the crime occurrence. Once you give the notice, your landlord can only hold you liable for 14 more days worth of rent. So that means 2 more weeks, you're still kind of on the hook for the rent, but after that, they can't charge you any more rent. That can be a huge positive in situations where especially if you still have an active lease, maybe you have 6 months left on it, you can't be held to that 6 months, 14 days only. But even if you're in a month-to-month situation, generally, normally under the law, you're required to give 30 days written notice before you can be let out of a month-to-month tenancy. And in this case, this cuts that in half. So it's very helpful provision. And the landlord also cannot keep your security deposit solely because you're terminating the lease under this section. So they can't say, well, you still have 6 months on your lease, so even though you're terminating, I'm going to keep your security deposit. They can't do that. But the caveat to that is that the normal security deposit rules do apply. So if you caused a bunch of damage in the apartment, if you're leaving it damaged, they're allowed to use the security deposit to address the damage, just like they would be when anybody's moving out of an apartment or a rental house. Okay, California, this is another new one, California section or Civil Code section 1946.9. When screening a prospective new tenant, the landlord may not or must not make adverse action based on any of the following, which are the tenant terminating their previous lease pursuant to 1946.7, which is something we just spoke about. So if you put your prior landlord as a reference and the new prospective landlord contacts them and tells them, this person had a lease with me and they terminated it because they were a victim of crime, that cannot be held against you. Another thing they can't hold against you is having previously requested to have your locks changed pursuant to section 1941.6, like we spoke about above. They also can't hold the fact against you that you or an immediate member of your family has been a victim of abuse, or that you previously called the police or emergency services to the home. So that's an additional protection. So when you're searching for new housing, you're not in a situation where the abuse that you endured is being held against you. And then utilities. So PG&E's rules make each adult living in the home equally liable for utilities. So what does that mean? That means if you have a $200 power bill and one person disappears and there were two people living there, the other person who hasn't disappeared is technically liable for the whole 200. And this can be obviously a problem if one of the adults is moving out and leaving behind existing debt. The other person could be on the hook. Or if you move out and you don't take your name off the account and the person's still living there, runs up a huge bill and doesn't pay it, PG&E might come looking for you later to pay the bills while you weren't even living there. So it's important that if you do move out and you were on the utilities, that you work on right away getting your name off the account so that they don't, they know you're not living there and they know you're not the one running up the charges. You also have the right to dispute utility debt. So if if you can prove you were living somewhere else at the time the debt was incurred. So even though technically you are liable for it, if this situation arises and you've moved out, you can dispute that, and you can do that by filing a complaint with California Public Utilities Commission, the Consumer Affairs Branch. So also an extra protection is that the Public Utilities Code section 394.4 requires utility providers to keep your information confidential unless you consent to its release in writing. And then can always be helpful. Just talk to your provider. So if you're the one moving out, like I said, you want to make sure you try to get your name off the account as soon as possible. But even if you're staying, every situation is different. But talking to your provider is always a good idea. It's not mandated by law, but a lot of providers might be willing to waive deposits for survivors of domestic violence. They may also be willing to arrange a more flexible payment option. So you always want to kind of explore that option, let them know what's going on, and it may be helpful to you. They may help you out. So that is the end of our presentation for today. Hopefully this answered your questions. If it did not, or if you find yourself in this situation, you can always contact us at HERA, Housing and Economic Rights Advocates. We provide free legal counsel for people in having tenants' rights issues, and this will definitely fall into that category. So you can reach out to us, ask for an intake appointment. We'll set you up with an attorney at no cost, and we'll do the best we can to help you address your issue, become aware of your rights, and if we can, advocate on your behalf, we'll do that as well. Thank you for watching this. Again, I hope you found it helpful, and hopefully you won't need our services, but if you do, we are definitely here to help. Thank you.